that this court is not independent and impartial. 4, that this court has no jurisdiction to try civilians. 5, that Regulation 63(2) of the Rules of Procedure makes this court not independent. 6, that Regulation 69(2) of the Rules of Procedure makes this court not independent. 7, that there is a question of freedom from discrimination in line with Article 21 of the Constitution. 8, that this court has no jurisdiction over offenses of unlawful possession of firearms under the Firearms Act. Counsel for the accused made lengthy submissions and cited to this court a number of authorities to support their arguments, and pray that this court be pleased to allow the application and make a reference under Article 137 of the Constitution. In reply, counsel for the state opposed the application and submitted that some of the issues raised were determined by the Court of Appeal, which also sits as a constitutional court, and cannot be referred to the same court because the state appealed to the Supreme Court. Counsel further submitted that there are other sections in different enactments which gives court jurisdiction for offenses committed outside Uganda, AG, the Penal Code Act, and Anti-Terrorism Act, so UPDF Act is not unique. Counsel also cited cases to support the arguments and submitted that since there is an order for stay of execution in the Kabazuguruka case, that is why this court maintains hearing of the cases under Section 117 G and H of the UPDF Act. On the Regulations 63(2) and 69 of the UPDF regulations, counsel submitted that the judge advocate under Regulation 63(2) advises court, and where court finds otherwise, they have to give reasons in writing. For Regulation 69, that this court seeks guidance from appointing authority on matters of law, counsel submitted that it does not happen. In rejoinder, counsel for the accused retaliated earlier prayers that this court allows the reference. This court, after listening to the submissions of both counsels, considered the relevant laws cited and specifically Article 137 of the Constitution has deliberated on this application and finds as follows. 1, that most of the points raised have been decided upon by Court of Appeal, which also sits as a constitutional court, but the state appealed to the Supreme Court. 2, that the alleged defect in a charge sheet is a matter that can be resolved through an appeal to the Court-Martial Appeal Court. 3, that Regulation 69 is an old regulation which has never been applied because it is not in conformity with the UPDF Act and the Constitution. 4, that the reading of Article 137(5) is that A and B have to be read together and not in isolation. 5, that the word may in Article 137(5)(a) gives this court the authority to give its opinion whether the questions advanced involves a substantial question of law, and where a party to the proceedings requests for interpretation, the court has to agree or disagree whether to make a reference or not. In the result, this court finds that since most questions raised were decided upon the Court of Appeal, which also sits as a constitutional court, and the matter is on appeal, especially in the Kabazuguruka case, this court declines to make a reference as prayed by counsel for the accused. This court will continue hearing the cases following the order of stay that was given by the Supreme Court, and the application is hereby declined. The accused should take plea. We sorrow done at Makindi this 14th day of Jan 2025 under my hand and seal of this court. Yesterday we were on count one.
Mr. Chairman, we have a prayer. Mr. Chairman, we have a
Council
prayer.
let us proceed.
Yeah,
You talk after you.
We are proceeding under the law, Mr. Chairman. We have instructions under the UPDF Act, Section 225, to appeal that particular ruling you have just delivered, subject to an appeal, Mr. Chairman. And this particular provision, Mr. Chairman, provides that a party to the proceedings of a unit disciplinary committee or court martial, other than a field court martial, who is not satisfied with this decision, shall have the right to appeal to an appellate court on any or all of the following matters. A, the legality or propriety of any or all of them. A, the legality or propriety of any or all the findings. So the accused persons are aggrieved by your decision on this issue. And under this particular provision, they are desirous of appealing to the appellate court within the framework of the UPDF Act. So we pray that you be permitted to proceed.
No, Council Kwagwa, I'm not permitting you this time. Since morning we have talked about almost all laws, and we have been treating on the same laws. Let's finish this process of pre-taking, and others will follow. Yesterday we had done with Captain Ora on count one. And this issue came when Colonel retired Dr. Chiza Vesje was supposed to take plea. And now to Colonel retired Dr. Chiza Vesje. On count one, as you heard yesterday, do you accept or you don't accept?
Mr. Chairman, do I have the right to appeal the ruling that you have just made, or I don't?
I think,
You
sir,
can guide on that.
the ruling, the appeal is not on the ruling. So let us proceed.
But
Mr. Chairman,
then now what are you appealing on?
we want to refer you to that section to 225, that a party to the proceedings of a unit disciplinary committee or court martial, other than field court martial, who is not satisfied with this decision, shall have the right to appeal on appellate court on any of all the following matters. 1, the legality or propriety of any or all the findings. The legality of the whole or part of the sentence, severity or leniency. It doesn't say that it has to be the final findings. So we are saying that this section gives our clients the right, automatic right, which is not debatable because it uses the word shall. If the framers did not want people to appeal at any stage of the trial, they would say so and say that you can only appeal on the final orders. That is not the wording. want to ask for copies of proceedings and certified copies of proceedings and ruling to enable us to appeal.
Let us proceed with pre-taking. Your appeal on the final decision of the court. The one interpreting the A, which is relying on.
No, listen, I don't know which justice you are talking about because it is for both sides, for us all. Taking plea does not mean that the case is concluded. In fact, it is almost as if it has not started. So, taking plea does not mean that the case is concluded, and I'm not allowing anybody to submit until we first finish this process. So Kano, retired Dr. Chizabesigye, once again,
Mr. Chairman,
do you accept or do you not accept?
I decline to take the plea.
A plea of not guilty entered.
That is the rule.
Haji Obedia Rotary, have you heard and understood the charge read to you on count one?
I decline as my colleague.
A plea of not guilty entered. On count two, statement of offense, treachery, contrary to section 127D of the UPDF Act, cap 330, particulars of offense. Captain Dennis Ora, Colonel retired Dr. Chizabesigye and Haj Obeid retired between February 2023 and November 2024, having vital information regarding meetings to solicit for logistical support with the intent to prejudice the security of the defense forces, consciously withheld the said vital information from the proper authorities. So, Captain Dennis Ora, have you had understood the charge read to you on count two?
I have heard and understood.
Come again?
I have heard and have understood.
Do you accept or you don't accept?
No, I don't accept.
A plea of not guilty entered on count two. Colonel retired Dr. Chizabesigye, have you had understood the charge read to you on count two?
I decline as before.
A plea of not guilty entered. Haj Obeid Rutare, have you had understood the charge read to you on count two?
I also decline as before.
A plea of not guilty entered. Statement of offense on count three, an unlawful possession of firearms contrary to section 4, subsection 1 and 2 of the Firearms Act, cap 320. Particulars of offense. Colonel retired Dr. Chizabesigye and Haj Obeid Rutare on the 16th November 2024, while at Riverside apartment in Nairobi, Kenya, we are found in an unlawful possession of a pistol model 27 KAL number 765, which is ordinarily a monopoly of the defense forces. Colonel retired Dr. Chizabesigye, have you had understood the charge read to you on count three?
Yes, and I decline as before.
A plea of not guilty entered. Haj Obeid Rutare, have you had understood the charge read to you on count three?
Yes, but I decline.
A plea of not guilty entered. Statement of offense on count four, an unlawful possession of firearms contrary to section 4, subsection 1 and 2 of the Firearms Act, cap 320. Particulars of offense. Kano retired Dr. Chizabes and Haji Obeid Kamri Rutare on the 16th November 2024, while at Riverside apartment in Nairobi, Kenya, were found in an unlawful possession of a pistol model HB 1015 1953, which is ordinarily monopoly of the Defense Forces. So, Kano retired Dr. Chizabes, have you had understood the charge read to you on count 4?
I do, and I decline.
A plea of not guilty entered. Haji Obeid Rutare, have you had understood the charge read to you on count 4?
Yes, and I decline.
A plea of not guilty entered. A statement of offense on count 5. An unlawful possession of ammunition contrary to section 4, subsection 1 and 2 of the Firearms Act, cap 320. Particulars of offense. Colonel retired Dr. Chizabes and Haji Obeid Rutare on the 16th November 2024, while at Riverside apartment in Nairobi, Kenya, were found in an unlawful possession of 08 rounds of live ammunition, which is ordinarily monopoly of the Defense Forces. So, Colonel retired Dr. Chizabes, have you had understood the charge read to you on count 5?
As before.
A plea of not guilty entered. Haji Obeid Rutare, have you had understood the charge read to you on count 5?
Yes, and I decline.
A plea of not guilty entered. State.
The case be adjourned to 3rd of February for further mention, and the accused persons be committed to their respective detention centers. 3rd February.
Mr. Chairman, with your permission. Thank you. And, 2 requests or applications. The first one is in respect to section 225, which my colleagues alluded to. And I am raising in light of the advice from the JA. The JA took the view that the appeal or the right to appeal should not be exercised at the final stage, as I understood it. I hope I'm not misquoting him. Mr. Chairman, the reading of section 225, if we read it a little slow, it says, a party to proceedings of a unit disciplinary committee or court-martial other than a field court-martial who is not satisfied with its decision shall have a right to appeal to an appellate court on any or all of the following matters. Mr. Chairman, 2251A says the legality or propriety of all or any findings, and B, the legality of the whole or part of the sentence, and C, the severity or leniency of the sentence. Because this is a court and the matter before this court is of a criminal nature, Mr. Chairman, the finality or the final decision would come with a sentence or an acquittal. And perhaps that is where subsection 1, paragraphs B and C apply. Subsection 1, paragraph A does not apply to a sentence, but applies to the legality of all or any finding. Mr. Chairman, a decision in this case is a finding. We want to distinguish it from a judgment which, even though is a finding, is not a final finding. So in this case, there was an objection raised regarding whether or not the accused persons, 813, should plea. They exercised their right to raise an objection. The objection, as we have heard from the ruling handed down by the court, has been declined or has been dismissed, and that, in our view, is a finding and also a decision. It's not a decision in the context of a sentence so that A and B of subsection 1 can apply. It is a finding regarding the objections raised, 1, and also the questions for a rephrase. So it is our request that, unlike the advice of the judge of the JA, the right to appeal envisaged in section 225 1A and B is not at the end of proceedings. It is in respect to the legality or propriety of any finding, including the finding which the court has just handed down. So we do pray that the court permits that the accused person exercises their right to take the decision regarding the application for reference to the higher court. 2, Mr. Chairman, is that in exercising their right to appeal, and as the sections envisage, in sections 227, is section 227 1, 2, and 3 requires the filing of a notice of appeal and also a memorandum. The memorandum can only be produced because the memorandum states the grounds of appeal. We can only fine-tune them when we have obtained a record of the proceedings, of what transpired in the submissions yesterday and today. The state has asked for up to 3rd of February. Today is the 14th. We have 17 days to end January, plus 3 is 20. We request the disciplined force to, in the interests of the accused persons, to use these days to prepare a typed record of appeal, which can be availed to counsel, record of proceedings, which can be availed to counsel, such that they can pursue the remedy available under section 225, which is the right to appeal. Mr. Chairman, in the other courts, there's a distinction, or in the laws setting up the other courts, there's a distinction where a right of appeal is granted as of right, and where a right of appeal requires the permission of the court. In this case, it says that the accused person who is a party to proceedings, it could be the state or the accused person, has a right to appeal. That right, therefore, is not based on the permission of the court. So we are not seeking leave of court to appeal. We are advising the court that the accused person has got the right to appeal, and they are exercising that right, and they are therefore asking to be supported as the law envisages, so that they have a copy of the record of proceedings, prepare their grounds of appeal in the memorandum. We also request that the court avails us a ruling, one which has been delivered a few minutes ago, and Mr. Chairman, you made an order that we availed a copy of the ruling in light of the objections which were availed today. The registry state have not done so. They are not yet, because the order made by the chairman was lawful, they are not yet committing a service offense of disobeying lawful orders. So we hope that they'll oblige, because the ruling has been delivered, it has been signed, and perhaps that in your presence, they will do at least that one of giving us the copies of the rulings which are ready. Otherwise, we are likely to see our land friend Colonel Raphael on the 3rd of February when we are lodging our application for contempt of your orders, Mr. Chairman. We request.
That one has no problem, and even the rulings that we have made have no problem. Maybe on the matter of Row JA can guide us.
They understood no problem to mean give them, or they mean the same thing. But we ask, Mr. Chairman, that the court commands that please hand over those rulings now because they are ready. Yes.
Pronounce yourselves, please.
I think, sir, let me clarify on those issues. The question of the record of proceedings, the ruling you are talking about, the registry falls under my office. As you can see, we have worked throughout the whole day. There is no way you are going to force the registrar to hand over the ruling now. You can come for it tomorrow, but you cannot say I want it now. Secondly, the question about appealing and the record of proceedings, I advised this court that a ruling, you appeal against a final decision of court. And therefore, you cannot try to turn out words to convince the chairman. When I advised the court, we went into plea-taking, and we have finished. So the next time is adjourning the next date, and any matter arising, we shall take it from there. That is it, sir. Otherwise, whatever they are seeking, I think we are being off track. We need a date for the next hearing.
Mr. Chairman, a very brief rejoinder.
No rejoinder. There is no rejoinder. For me, I am mandated to advise on the court, and when I address the court, it is not me between me and the state or whatever. No. That is my role. So, sir.
We also, with respect, have a role to persuade the court not to take the advice, especially when it's deliberately misleading.
Not when I have talked.
Allow us. No, you can't. What is the use of having a panel?
Ceasefire Council, Senior Counsel, Karua. We are adjourning this case, and if there is any matter, will be raised on this adjournment. And Captain Dennis Ora and Colonel Dr. Retired and Haj, your case is adjourned up to 3rd Feb 2024 for further mention.
Are there investigations going on?
What?
Are there investigations going on? They just say it. Are there investigations? I think it's conducting investigation.
Council, that's what I have said. On the next adjournment, please.